in regard to what are proper funeral expenses. See hereafter. For the purpose of preserving the property, the executor need not take it into his possession or remove it from the charge of the family of the deceased, unless he has good reason to suppose that it is being wasted or neglected, in which case he has power to take it, and he should do so for his own protection. He may doubtless convert into many perishable articles which could not be kept long enough to be inventoried, where the effect or the charge of the person not interested in the preservation of them, the executor ought to care for them and remove them, if necessary. And he will be protected in taking steps for that purpose. He may take the papers of the deceased and seal them up, awaiting further authority, and deposit them in a place of security. The will of the deceased should be open and its content ascertained as soon as practicable after his death, for the purpose of learning if any directions are contained in it in regard of his funeral or the immediate care of his family. There is in some parts of the state a practice of waiting for 6 weeks after the death of testator before opening the will or taking any steps to prove it. This is founded in sentiment of respect for the deceased, but is a mistaken exercise of it. For the best way to manifest such respect is to regard the wishes of the deceased and take immediate steps to carry them into effect, which can only be done by approving his will and caring for the estate which he accumulate for his family. In this connection, it may be well to state the liabilities of any unauthorized person taking possession of the property of the deceased, as regulated by the law 60.2R.S.81, 3 R.S.5th edition 168. When executor de Santort afterward takes letter testimony, his responsibility relates back. 10 page. To the death of the descendant. To the death of the descendant. Or to his own first act of unauthorized interference. Estate Ellen Farwell, Tucker 110. Every person who shall take into his possession any of the assets of any testator or intestate without being thereto duly authorized as executor, administrator, or collector, or without authority from the executor, administrator, or collector, shall be liable to account for the full value of such asset to every person entitled thereto, and shall not be allowed to retain or deduct from such assets for any debt due to him from the deceased personally in his lifetime, but he may retain any such assets for the sum due to him for care taken of them, or for labor expenses on them, and demand payment of a lien so acquired before delivering them up, or he may have such sum allowed him in accounting for the goods or the value thereof on a trial of law. 17 page 449, 3 RS 5th edition 747. No person shall be liable to the executor of his own wrong for having received, taken, or interfered with the property or effect of the deceased person, but shall be responsible as a wrongdoer in the proper action to the executors or general or special administrators of such deceased person for the value of any property or effect so taken or received, and for all damages caused by his own act, the estate of the deceased. It may be remarked that anyone performing the Christian service of burying a deceased person will be allowed his reasonable funeral expenses out of the estate of the deceased as a debt preferred above all other debt. Who may appoint an executor and who may serve as such, disabilities how removed. statutes as amended by the Act of 1848 and 1849 in respect to the rights and powers of a married woman provide that all persons except idiots, persons of unsound mind, and infants may devise their real estate by last will and testament, and that every male person of the age of 18 years of upward and every female of the age of 16 years of upward of a sound mind and memory of no others may give their banquet of his or her personal estate by will in writing. An alien cannot take or give real estate by devise, but his will in regard to personal property will be carried out. The power to make a will involves the power to appoint executors, but 3.2R.S. 3 RS 5th edition 154, no person shall be deemed competent to serve as an executor who, at the time the will is proved, shall be incapable in law of making a contract except married woman under the age of 21. 13th page. An alien not being an inhabitant of this state, McGregor versus McGregor. I'm gonna forward this because I'm pretty sure I have stated this already. So I'm gonna go to 16 because I think I did that on the last video. The duty of executor in proving the will. There is no absolute necessity that application for the probate of a will be made by executor. It may be made by any person interested. Even a creditor may make the application and procedures to necessary citation in case those more immediately interested neglect the duty. But the application should be made usually by one who intends to act as executor, and he should, by diligent inquiring, ascertain, if possible, the names of residents and the heirs of at law and next of kin of the testator, so as to inform the surrogate of the requisite facts. 5th S.L. 1837, chapter 46, 460, 3 RS 5th edition, 146. On application to the surrogate, he shall ascertain by satisfactory evidence the following facts. If the will relates exclusively to the real estate, the names of the places of the residence, the heirs of the testator, or that upon diligent inquiry the same cannot be ascertained. If the will relates exclusively to personal estate, the names and places of residence of the widow and next of kin of testator, or that upon diligent inquiry the same cannot be ascertained. If the will relate to both real and personal estate, the names and places of the residence, the heirs, widow, of the next kin of the testator, or that upon diligent inquiry the same cannot be ascertained. The diligent inquiry required is seeking the requisite information from those who, by reason of relationship to the testator, intimate acquisitain, may be expected to know of his family, or would her caution parties not to confound the terms heirs and next to kin in the statute with legatees, and devices in the will. The term heirs and next of kin imply a blood connection, while the relation of the legatees and devices arise from the will, and the testator where I'm at here. Here's the distinguished also from the next of kin, the first taking the real estate by decedent, and the last taking the personal property by distribution. Thus, the heirs of the deceased person are 1. His children lawfully begotten, if he have any, and the children of such as shall have died. His father, if he is being living, his mother, if she be living, his collateral relatives. 3RS 41. The next of kin are the children, the father, the mother, the brother, the sister, and the legal representatives, that is, the children of such as shall have died. His collateral related is not beyond brothers and sisters' children. Number 2, R.S.96, 3RS, 5th edition of 183.